this thing goes off, will you let me know?
Yep.
It shouldn't this time, I've dumped everything out of memory. Okay. Who watched the film? I know you did, Uh-oh.
I wasn't here last week. I
Um,
didn't know to.
What did you think, first of all, of the film?
What do I think about the film?
Yeah, about the film, what did you think about it?
I thought it was like, as a movie, I thought it was okay, but it was a good representation of, like, all the, like how that works.
Yes.
I don't want to use those wrong terms, but it's like how, like, sports and all that works.
Exactly, that's the reason I wanted y'all to watch it. What legal term were they going after to prove whether or not she was capable of standing trial?
I don't make the same as uncompetent.
Do what?
Uncompetent.
There's another word, it's a legal word that they were going after. Competency is one. It does begin with a C. It's capacity. Was she capable? Now, I really liked what the judge did at the very last. He said, I don't really think that you need to go into court without more psychiatric tests and such. And I don't think, I think that you need to build up your case a little bit. But what were the things that he decided the case on?
If she can fight her own trial, if she can do her own,
Do what?
defend herself in the trial.
She could assist in her defense. Okay? She could understand what was going on. Okay? And those are very, very important in talking about capacity. Do you have the capabilities of understanding what is going on in this trial, and are you capable of assisting in your own defense? And I liked the way, you could see how the trial progressed, and, the workings, and especially like at the very front end when, you have the big shot lawyer come in, and everybody else has to move their docket because the judge liked this guy, and he moved that case up, But it happens that way, Did y'all have any questions?
I do.
Yay or nay, thumbs up or thumbs down on the movie?
I like it.
Okay. Is that a thumbs up?
Yeah.
Okay. I didn't show it to my last class, and I've been, I toyed with the idea, but I think that it kind of illustrates some things that is very important, that blends in with this chapter. Okay. Well, let's go ahead and move on to the Bill of Rights. We've talked about the First Amendment. 5 things in the First Amendment. Listen, we got 5 people here. Who can tell me one of the things? Who said freedom of speech? Okay, freedom of speech.
Freedom of religion.
Freedom of religion.
I'm just the same thing she said.
I could say another one. Petition. What she said.
Right to petition. That's 3.
Peacefully assembled.
Peacefully assemble. That's 4. Now I gotta think what we missed.
Press.
Huh?
Press. Like freedom of the press.
Oh, yeah, freedom of the press. All right. It's interesting, they put those 5 as the very first thing. What would that tell y'all?
Most
That they thought that
important.
was important.
Exactly. This is really important, folks. These are some basic freedoms that we don't want messed with. These are some basic freedoms that we have a right to. And we're going to put it down as clearly as possible We have the right to free speech. We have the right to freedom of the press. The state cannot make a state religion or inhibit the practice of a religion. We have a right to peaceful assembly. Okay, I'm missing one.
The press,
Did I say the press? I don't think I did. And we have the right of the press. We also have the right for petition of grievances. Okay? So, this is something those guys thought was so important, it had to be number one. What's the Second Amendment?
Right to bear arms.
You have the right to bear arms. Now, anybody want to pull that up for a second on your phone and read it exactly as it's written?
A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed.
The right of the people shall not be infringed to be able to bear arms. Now, we've already said that you have to have a license or a permit to carry arms until this Attorney General, that you could only have concealed weapons, and she says that carrying open is legal. But there's a conflict there, and that has not actually been clarified by the legislature. But is requiring a permit infringing upon our right to carry arms or to bear arms?
Absolutely.
Mm-hmm. Absolutely. And, it depends on the court, on the makings of the court, on how they would rule. But, yes, if you really look at it, a permit is an infringement upon your right to bear arms. The Third Amendment, they don't throw out for you. All it says is that you cannot be forced to quarter or house troops in times of peace. So they can't force you to let soldiers stay in your house if it's peace, if we are not at war. Now, if it's at war, then that's another thing. But the reason this was brought about was that the colonies, the British forced people to house and take care, feed and give the British troops a place to eat and sleep. And they were forced to, whether they wanted to or not. This is another part of the Bill of Rights. That this was a problem, this was something that they were worried about, this was something they didn't like. It was important to them, so they put that as number 3. Okay, so we have not talked about the Fourth Amendment. So, let's get it done. Fourth Amendment. Anybody know what the Fourth Amendment is?
Search and seizures.
Search and seizure, absolutely. It also, if I'm not mistaken, it is part of the due process. There's 2 amendments they have combined now and called due process clauses. And the fourth is one of them. What does search and seizure mean?
They must have a warrant.
What?
can't come in your house and see how it's doing.
They cannot without a warrant. Now, there are some circumstances that can be, negated. But generally, they cannot come in and, search a house without a warrant, search a car without a warrant, search you without probable cause. Okay? Now, when they write up a warrant, you will be amazed at how specific it has to be. It doesn't say, Judge, we wanna go to, 123 Main Street at any town, Arkansas, USA. We think they've got some illegal stuff. Judge is not going to appreciate that a bit. You have to list the exact items that you are looking for. And sometimes, when we get Mike over here, I'm gonna try and get him over here maybe Monday. He's my cop friend, and he will really surprise you at telling you everything that needs to be done as a cop does. But the specifics is amazing. We will be searching for a Winchester 30-06 rifle, and it's described. It'll have to be described as best as they can. That was involved in such and such a crime on such and such a date, and everything has to be absolutely spelled out. Okay? Now, he gets a warrant. Cop gets a warrant. He has a warrant to look for a rifle, and when he gets in the house, he starts looking inside drawers. Why is that illegal? Why is that an illegal search?
Because the rifle will fit in there.
The rifle will not fit in a drawer. And so, because the rifle will not fit in a drawer, he cannot open those drawers. Now, he walks in, and there's a brick of weed on the table. Can he do anything on that?
Yeah.
Yes. That's in plain view. That's called the plain view doctrine. And if he sees it and it's in plain view, then he can go after it. But he's looking in a closet for that rifle, and he sees a brick of weed. Can he seize it?
Yeah.
No.
No.
It's not in plain view, and it was not on the warrant that he was looking for marijuana. And so he would have to secure the house and go get another warrant to get the marijuana. It has to be specific, absolutely specific. And, all of this really surprised me when I started writing up warrants. They're just very technical. And the judges, they get to know you. And, if you're really good and dot all your I's and cross all your T's, they learn to trust you, and then they'll just kind of scan over. They'll make sure it's in order. But, if you screw up a lot, they're going to sit there and they're going to read every word and make sure that they cover themselves. Because if they sign a bad warrant, it goes back on them. Okay? So we know search and seizure is with the Fourth Amendment. Let's see what else I have written about the Fourth Amendment. You cannot detain a person without proper justification. So, you have a cop the cop is riding along and he sees somebody that has really, really ruffled clothes, kind of looks like he hadn't had a bath in several weeks. He just sitting there with a backpack. Can he stop and question that guy? He can't detain him. There's no reason that he has to question that guy. Now, on the other hand, if over the radio it says that there's a crime that has been committed and they just give a description of the clothes that the guy's wearing, that he carries in such and such a backpack, then the cop has a right to go and talk to him. Now, another thing, dogs have gotten into this search and seizure thing now. Cop will pull you over, and he thinks that there's reasonable suspicion to think that you've got drugs in your car. And he says, would you mind if I took a look? Can I search your car? And you say no. First of all, because of Illinois versus Caballos, he cannot detain you an unreasonable amount of time waiting for that dog to come. I'm not sure, it may be 45 minutes, it may be less, but you cannot detain somebody waiting for a dog to come to search, to sniff the car, and an unreasonable amount of time. And I think they've set that at 45 minutes. All right, so the dog hits on the car. Now they've got reasonable suspicion to, and probable cause to go ahead and search the car. And they can do that then. The courts have ruled that's permissible. So, first thing that, I'm gonna tell y'all is if you get stopped and you're guilty, don't give them permission to check your car, make them wait. Secondly, don't say anything except I want a lawyer. And if they pull you in, I want a lawyer. That's all you need to say, because otherwise, I'm telling you, you can get yourself in trouble. Mike will really fill you in on stuff. He'll even fill you in on some of the things that the detectives use, some of the tricks the detectives use to get people to confess to stuff. He's had guys that have said, we want a lawyer, okay. And, he and another cop will sit there and talk about what they know, and then put the guy in such a panic that he'll revoke his lawyer, his request for a lawyer. Mike's got 30 years experience on being a cop, and he's one of the best in the state. He's known as one of the best detectives in the state. And so he usually comes to my class and talks about, the police stuff. Okay, so the Fifth Amendment, search and seizure. Now, we have a term that we use, and I'd like to know if anybody really knows what it means. Due process. We talk about due process. That is a major component in our judicial system. We have a right to due process. As Americans, we're one of the few countries that the citizens have a right to due process. Well, it means, first of all, that you have a right to a fair trial. And it also means that prior to that trial and through that trial, you have a right for all the legal procedures to be carried out to preserve your rights. That you have a right for fair treatment throughout the judicial system. The judicial system has to adhere to your individual rights. It's fundamental fairness. And no citizen can be deprived of their legal rights. All of this is under due process, and it's major. This is major. Now, one of the things that was discussed in your book was how the courts changed with the appointment of Earl Warren as Chief Justice. It was at that point that the Supreme Court made a major turn toward being an activist court as opposed to a constitutional court. A constitutional court, one that actually interprets the Constitution the way it was written, and an activist court is a court that will basically legislate and change laws that basically were not written that way. An example is Second Amendment. I believe it was the Warren Court that said, okay, they didn't know about automatic weapons, and so you have to look at the Second Amendment as and you have to look at the Constitution as a contemporary document and make these rulings on contemporary circumstances. So, since they didn't have automatic rifles back there, they couldn't put in the Constitution that you shouldn't have automatic rifles. So we have to make that determination.
But that door swings both ways.
Yes, it
Who's to
does.
say they wouldn't have if they had the right to, or if they had to?
Exactly. And the thing about an activist court, this is what I really, really want y'all to think about. The last class I had 2 or 3 that said, oh, we need an activist court. We've got to have an activist court. You're right. The door swings both ways. All right, we have an activist court that says, okay, we need to throw away all of our protection for the victim and protect the defendant's rights. All right? You have another court come in and say, oh, no, we got to do it this way. If they make the determination on the law and interpreting the law, that's where it's fair. Because otherwise, Roe versus Wade is a perfect example. That was a legislative move by the court. Now, for 30 years, I guess, maybe 40 years, there's been arguments on, first of all, whether it was legal for the courts to make that jump and to legalize abortion throughout the 50 states. Okay? Now, they made that jump, and they say, okay, the states, the laws were all unconstitutional, so there is no, the woman has the right throughout the entire 9 months, up to the point of birth, to abort that baby. Now, it's getting pushed to after the baby is born. If the abortion produces a live baby, they can still kill it. Now, that's when you have an activist court. And they have made these assumptions. All right, so you've had an activist court for 30 plus years. Now you get a court on the other side, and they start changing these laws, and that's the problem. You have this back and forth, and it's not only confusing, but there's always somebody who says, let's use the courts to do things our way. That's what happened. The abortion, it was tested, many states said, we don't want abortion, and so they passed laws against abortion. These organizations, they said, okay, we want abortion legalized. They couldn't pass it in the states. So what did they do? They got a test case with an activist court, and that test case came along and threw out all the laws. Even though the people passed these laws, the court threw out the people's will. And now there's been a fight for the last 30 to 40 years on whether it's legal and whether we should get rid of it or whether it should stay. If it was decided as the law is written, there wouldn't be that kind of confusion. But now we're getting to the point we've got activist courts versus the original intent courts, and it's gotten to the point now that instead of asking some prospective judge that is going through the hearings on how well he knows the law, he's being asked, what do you think about abortion? What do you think about Roe versus Wade? What do you think about this case? And they're determining it on their personal opinions about and their personal stances instead of their judicial record. So that's why I'm kind of pounding on this, that we need to have people that will interpret the Constitution instead of legislate through it. Okay. You talk about the Fourth Amendment. What about the Fifth Amendment? Self-incrimination. You do not have to testify against yourself. You do not have to give information that will incriminate yourself. You can't be forced to do it. Now, another part of the Fifth Amendment, double jeopardy. Anybody know what that means?
You can't be tried for the same crime twice.
Yes and no. On the same level, you cannot. But let's say that you had a murder, and we'll juice it up a little bit. We'll say a murder of a municipal judge. Okay? Well, he can't be tried twice on that state level, but if the crime is both a state and federal crime, then they can try you twice. They can go to that other level if they missed you the first time. Let me ask you a question. Is it true that in all cases you're presumed innocent until you're proven guilty? Is that the presumption of our courts?
No, it's supposed to.
No.
It's supposed to be? Okay, you say no.
I say absolutely not.
Okay, why?
Because that may be the intent of where it started, but now you have to prove your innocence versus proving.
Instead of them proving you're guilty?
Mhm.
Well, and I've got something else that might, shake you up. If a person is in the military and they're tried, they are automatically deemed guilty and they have to prove their innocence. It is not assumed that they are innocent until proven guilty. They are assumed of guilt until proven innocent. And so, that is, something a lot of people don't know. So, double jeopardy we talked about, self-incrimination, okay? Let's see, is there anything else there? Sixth Amendment.
Speedy trial?
Do what?
Is it a speedy trial?
Speedy trial. Let's see, I'm thinking it's not. Let me look here for a second. It's the right to a counsel. Yes, it is. Right to a speedy trial, that's the second part of it. You have a right to counsel. You have a right to have a lawyer, and because of Gideon versus Wainwright in 1963, all trials, whether it's a municipal or whatever, you have a right to have a lawyer. Before, it was only like, you had a right only if it was like a death penalty trial. But now, you have a right to a lawyer with any trial. You need another thing that is somewhat new. A citizen has a right to know, or a defendant has a right to know if a plea deal has been offered. A lawyer cannot just say, oh no, that's ridiculous, and walk away and not tell the defendant that he's been offered this deal. Even if he thinks it's a crappy deal, and he can tell the defendant it's a crappy deal. But he has the obligation and the ethical obligation to say, here's the deal you've been offered. And that is, he has to do that now. At one time, that wasn't part of the law. You have a right to a speedy and public trial. Anybody know how that came about? Remember, these are the Bill of Rights written by our forefathers.
Well, they can't detain you until they find enough evidence.
And when this amendment was written, they were very, very worried because somebody would be taken, arrested, and they could be put in jail and held in jail for years without a trial. And they were worried that our system could get back to that type of actions. And so they said, no, we have a right to a speedy trial. Okay? The other thing that they say that we have a right to on that is a public trial. They can't arrest you in the middle of the night, take you to some judge that is meeting a special court who tries you and then throws you into jail, and then you're SOL now for years and years. You have a right to a public trial. Now, that does not mean that every trial the judge has to let every person in. He does have to let the public in. It might just be the press. It might just be, a certain group that he has allowed, but he cannot keep the trial secret. Now, you have what's called a grand jury. And the grand jury trial, it's more on a secretive basis, and it's not really a trial, it is a jury that is getting a fact-finding, trying to locate evidence, trying to see if there's been a crime committed. And then if they think that a crime's committed, they will come back and say, we think there's enough evidence that this person is guilty and needs to go to trial. And then you have your public trial. But your grand jury is very, very tight on any information getting out. But it is really not a trial per se. Okay. Third part of the Sixth Amendment, you have a right to an impartial jury. What this means now is you have a right to a cross-section of people in your community. It would be very, very hard to actually get 12 people out of the jury pool that was your basically actual peer. Geologically, or not geologically, your area, your age, your occupation, it'd be really hard to get an actual 12 people of your peers. Does anybody know how you wind up on a jury? How you serve on a jury?
Registering to vote.
In the mail.
You what?
You just get a letter in the mail or something.
Okay, how do they come up with names to send letters in the mail? Yes, ma'am.
Don't they ask you like questions, like you also try?
Do what?
Don't they like ask you certain questions?
After you get there, how do they choose people to send these letters to?
Is it a lottery?
A lottery?
Is it a lottery? Like a draft?
Not really.
Registering to vote.
It's, many times it's either your driver's license or your registration to vote. And what they do is they take all those names and then they'll pull a certain number of those names and they'll send those letters out and say, you've been chosen to be potential jury members for the next 6 months. And the way they do it here in Arkansas, in Little Rock, is the bailiff will tell you, okay, we don't know if there's gonna be a trial or not this week, so call, you're a Tuesday juror, he'll say, call Monday, and you'll have a recording, and he'll tell you whether or not there'll be a trial the next day. If there is, you have to show up. If there's not, don't worry about it. So, you get the call and you go in, and they will put, I'm not sure if it's your name or a number, in a big bowl, and they'll pull out like 25. And then they'll say, okay, here's the people here's our jury pool right now. So then, they'll go to each person and ask them a series of questions to see if you have a bias or any kind of conflict of interest. Now, there was one time, and it really kind of is funny, there was one time that I was on a jury pool, and they pulled my name, and they said, the lawyer, he said, are there any teachers in this jury pool? I raised my hand, and he said, where do you teach? And I said, well, I'm at UALR and I'm at Pulaski Technical College. Okay, what do you teach? I said, I teach psychology. Well, if this trial involved a teacher, do you think you could be unbiased and that you could hear the information and judge fairly? Yeah, I think so. Okay. So then they went through some other, things, Then pretty soon he said, do we have any therapists here? I said, and he said, okay. He asked me several questions about being a therapist and if I could be fair, and I said yes. And a few minutes later he said, do we have anybody here that's associated with the government? And I said, he said, in what capacity? And I said, well, I'm a deputy. And, the defense attorney came over, you know, and he said, do you think that all cops are honest? And I said, well, all I can say is I haven't met any that wasn't. And he said, Judge, I want to disqualify this person. And, you know, he disqualified me because I thought that I had never met a cop that wasn't honest. You know? Now, I'm not saying all cops are good. I'm not saying, you know, that, you know, there's bad apples in every group, in every barrel. But the thing is, we gotta get those guys out. And we gotta clean it up, you know, but we don't wanna throw out the baby with the bathwater. All right. The Eighth Amendment. You cannot be given excessive bail or fines. Okay? So, let's say that, you hit a judge's car 5 years ago and he recognizes you when you come up. Well, first of all, he ought to recuse himself. But let's say he doesn't. And you're there, because, let me see. Because of disorderly conduct, and public drunkenness, okay? Well, he sees you and, you know, he said, okay, your trial date is such and such, and your bail is $3 million. That's excessive, and that's not allowed. He's not allowed to do something like that, okay? It has to be a reasonable bail, and usually when you do a bail, you'll have a bondsman that will say, okay, I'll post it for you, but you have to come up with 10% of the amount. So like, if you did have $3 million, you'd have to come up with $300,000 to be able to get out if you used a bondsman. Okay. So, you have the right of reasonable punishment. So, you were you were drunk and disorderly, and you're under 18. Well, the judge can't say, well, what we're going to do is we're going to cane whip you and show you what, you know, how stupid it is to go out and get drunk. You can't do that. Okay? That's not allowed. You cannot have excessive bail, you cannot have excessive fines, you cannot have cruel and unusual punishment. All of this is under the 8th. It was Earl Warren that declared that you must use contemporary society to determine what cruel and unusual punishment is. This was the beginning of how he started being an activist. Juveniles cannot receive life sentences for non-homicidal crimes. So, you know, even if it was a very, very horrible crime, they can't be sentenced to life for it unless it was murder. And then now we're even getting some hinky things about that, because we've got several cases where kids were young and they did some horrendous crimes, and they were transferred over, I think, to adults. Yeah.
Why do people get like multiple life sentences?
Okay, that is a great question. Question is, why do some people get multiple life sentences? Because they have been charged with multiple deaths. I mean, you know, like, let's say they killed 3 people. All right, let me, give you an example. First thing I can think about would be, a case like Charles, Whitman in, Texas. And he got up in the, tower at UT, and he took a gun and he started sniping and killing people, all right? I don't know how many he killed, and he actually was killed on scene, but if he had gone to trial, every person that he killed would be a separate count. So if he killed 4 people, that would be 4 counts of first-degree murder, premeditated murder. And so the judge then has to sentence for each crime that has been found the person guilty for. That's a great question. Okay, so now let me, where are we here? Ooh, almost at the end here. Now, where's my clicker? I've lost my clicker. Well, okay.
Is it in your pocket?
Oh, I guess I never put it out, okay, good. Very quickly, on the due process revolution, this began in the 60s with Earl Warren and the Earl Warren Court. They extended the due process clause of the 14th Amendment to include, I think, the 5th as well. Critics of these decisions believe they made the community more vulnerable, and they gave too many legal protections to criminals. But it also opened up a Pandora's box like I've been talking about. Let's see here. What's that? The 5th Amendment, I know you can't see that. Oh, okay, 4th Amendment. I don't have that on this one. The 4th Amendment, it protects people against unreasonable searches and seizures. It limits the ability of law enforcement to search a person or property in order to obtain evidence. And it limits the ability of police to detain a person without proper justification. Policemen cannot stop you without reasonable suspicion, and they cannot arrest you without probable cause. 5th Amendment. This outlines basic due process rights. You have protection against self-incrimination, double jeopardy. You have entitlement to indictment by a grand jury. You have citizens from the community that hear evidence. The grand jury is like I was telling you. Citizens, they hear evidence and determine whether enough evidence is there to charge a person, but this only applies in federal court. Otherwise, a prosecutor decides whether or not to charge you. And then one of the few rights the Supreme Court has not applied to the states. Okay, so the next one, 6th Amendment, provisions dealing with fairness in a criminal trial, such as right to counsel. I told you about Gideon versus Wainwright. Speedy trial, public trial, right to an impartial jury. The 8th Amendment, rights of the defendant during pretrial and correctional phases, prohibits excessive bail, excessive fines, prohibits cruel and unusual punishment. And there are 4 different Supreme Court cases that were involved with that cruel and unusual punishment. 14th Amendment was created after the Civil War. The 13th, 14th, and 15th Amendment. In earlier cases, the Supreme Court had basically operated under the fairness doctrine. The 14th Amendment. 14th Amendment is one that, let me get this because I think it has to do with equal protection. Equal protection for everybody. It barred states from violating people's right to due process. equal protection and protection from abuse. And like I said, equal protection. We're now finished with this unit on rule of law. That is the third unit in this group. It sneaked up on me, so I'm not going to say that everything's due by next week, but everything on this unit is due by, I think, October the 2nd. So all your unit quizzes, your unit quiz and all of your chapter quizzes have to be in by October the 2nd, because I'm gonna close out everything, and if it's not done, you'll lose those points.
The term paper as well?
The what?
The term thing, the term worksheet, whatever you gave us?
The term paper?
Yeah.
No, that's not due until, right before finals. Okay?
Do we have the class to work on that?
Will we have a class on that?
Like, will you ever set aside some time so we can work on this?
Well, that's why I've given you like 3 months to do it, so you can have some time at home.
Oh, it's 3 months.
Do it, okay. All right, any other questions? Well, we're gonna start the police chapter on Wednesday, and to me, that's a lot more fun. This has been kind of, all fundamental, foundational type of stuff. And like I said, I wanna get Mike in here, and then the fun will really start. All right, no questions? Comments? Criticisms? Y'all have a great week. We'll see you Wednesday. And it didn't